The purpose of this video is to prepare you for your mediation. A mediation is nothing more than an opportunity for both sides to get together to try to resolve, negotiate, or settle your claim. Oftentimes, both sides want to avoid the risks of going to trial, the costs of going to trial, and sometimes the stress and the anxiety of preparing and going to trial. The risk to a plaintiff of going to trial is that you may get a conservative judge or a conservative jury in a personal injury action. The risk to a defendant is the cost of going to trial and the fact that they may get a runaway type of verdict. I normally say that it's a good idea to do a mediation because it does set a deadline for both sides to have to make decisions about your claim. A mediation normally starts in a conference room where all the parties get together and meet and greet each other. You and your lawyer will go in and meet and greet the other lawyer and either a company representative or an insurance company representative. Then there will be a third-party mediator. The mediator's purpose is to be there and to be fair and impartial to both sides. In other words, he's not for your side, nor is he for their side. He is there in an effort to try to get both sides to reach an agreement. Now, opening statements will be made during the mediation, and occasionally the other side may say some ugly things about you or your case. In the unlikely event that that happens, please do not react to anything that is said. A mediation is not a court proceeding. Actually, either side can walk away during the mediation at any time, and it won't be held for or against either side in the event that the case is eventually tried by a court of law. There'll be no cross-examination nor any pressure upon you to perform. Actually, the mediation is very informal. They will, however, be evaluating you and your conduct, so your appearance will be very important. Your lawyer will discuss with you the value of your claim before the mediation. When the mediator comes into your office, be very careful about telling the mediator what your bottom line is. In other words, you should not tell the mediator what your bottom line is. If that happens, the mediator may try to work toward getting you that value as opposed to a higher value. If at any time during the mediation you feel that you want to talk confidentially with your lawyer, it's perfectly acceptable to ask the mediator to leave the room. It does not hurt their feelings, and it is perfectly normal procedure. If you settle during the mediation, papers will be signed outlining the agreement. You'll be told how long it will actually take to complete the deal. If you don't settle during the mediation, the negotiations may continue, and your lawyer will continue to get your case ready for trial. Your lawyer should also tell you approximately how long it will take before your case will be tried in a court. Now, your lawyer will sit down with you and come up with a range of values that he or she feels is the value of your claim. If the other side comes up with a negotiated figure that is well below the range, your lawyer will tell you to go on to court. If, on the other hand, the other side comes up with a value within that range, then you'll be able to decide if you want to settle your claim today. For a mediation to be successful, the range of values must be realistic. You wouldn't want to buy a $10,000 car for $30,000, and you wouldn't want to sell a $10,000 car for $1,000. So your lawyer will go over with you what he or she feels is a realistic range of values. I hope this video has been of some value to you, helping you prepare for your mediation. Your lawyer will meet with you immediately before the mediation, and if in the meantime you have any questions or concerns, please contact your case manager or your lawyer.